Hello guys, it's me again, Lovely Montalban. Welcome to my vlog!
Mama, a party girl, she just wanna have fun. They say you
So for today, we will discuss about the employer's rights vis-a-vis his employees. The interactions between an employer and his employees concerning the terms and conditions of employment of the latter constitute the substance of labor relations. They involve an interplay between and the balancing of each other's rights. The rights that are claimed by the employer flow from the fact of ownership of the business. They come with the territory, so to speak, and from what have traditionally been recognized as management prerogatives. The rights of labor, on the other hand, are established and protected by the law. In the case of San Miguel Brewery Sales Force Union versus Opel 170 Scrap 25, the Supreme Court defined the scope of management prerogative in relation to employment as follows. Except as provided by special laws, an employer is free to regulate, according to his own discretion and judgment, all aspects of employment, including hiring, work assignments, work methods, time and manner of work, tools to be used, processes to be followed, supervision of workers, working regulations, transfer of employees, work supervision, layoff, discipline, dismissal, and recall of workers. That statement covers the whole gamut of employer-employee relations, is one of the most often quoted in labor jurisprudence. Also declared in the same case, citing LVN Fixtures Workers versus LVN 35 SCRA 147, that so long as a company's management prerogatives are exercised in good faith for the advancement of the employer's interest and not for the purpose of defeating or circumventing the rights of the employees under special laws or under valid agreements, the court will uphold them. Subject to the caveat, labor laws discourage interference with an employer's judgment in the conduct of his business. Maya Farms Employees Organization versus NLRC 239 SCRA 508. The law, in fact, recognizes the right of every employer to strive for maximum profits, which is the motive underlying every business establishment, subject, of course, to the usual limitations. The freedom to administer the affairs of a business enterprise such that the cost of running it would be below the expected earnings or profit. The elbow room in the guest for profits is a management prerogative. Chu versus NLRC 232 SCRA 764. In the pursuit of the profit motive, the management is free to adapt and make changes or adjustment in organizations or operations that would ensure profit to the employer or protect the interests of the stockholders, including the merging or consolidations of the business with another, sale of all or substantially all assets which may bring about dismissal of workers, without, however, evading the obligations to the employees in the latter event. San Felipe Neri School of Mandaluyong versus NLRC 201 SCRA 478. That freedom includes the right of the employer to abolish positions deemed to be unnecessary. Kosha versus NLRC 272 SCRA 583 to reorganize and abolish offices. Arieta v. NLRC 279 SCRA 326. and to implement a job evaluations program. Hong Kong and Shanghai Banking Corporation Employees Union versus NLRC 281-511. However, reorganization cannot be used as a convenient device for getting rid of existing personnel and replacing them with new ones. Gregorio Araneta University Foundation versus NLRC 256-3A. It also includes the right to resort to force leaves of absence of employees during an economic crisis. Philippine Graphic Arts versus NLRC 166-118. The only criterion to guide the exercise of management prerogative is that the policies and rules and regulations on work-related activities of the employees must always be fair and reasonable, and the corresponding penalties when prescribed commensurate to the offenses involved and to the degree of the infraction. The Coca-Cola Export Corporation versus Cagayan 638-379. Take the case of BFOQ or Bona fide occupational qualification, which is a standard laid down by the employer for employees belonging to a certain occupation, which reflects an inherent quality necessary for satisfactory job performance. In order to justify a BFOQ, the employer must prove that 1. The employment qualification is reasonably related to the essential operation of the job involved, and 2. There is factual basis for believing that all or substantially all persons not meeting the qualification would be unable to perform the duties of his jobs. Star Paper Corporation versus Symbol 487-228. In the case of Ira Suge versus Philippine Airlines 569-467, the Supreme Court had occasion to put to the test the reasonableness of a BFOQ of PAL, which was the weight standard imposed by the company on its cabin crew. The test applied was the Miorin test, whose purpose is to determine the reasonableness of a company policy or standard. The court held that under the said test, the employer must show that it adopted the standard for a purpose rationally connected to the performance of the job. B. The employer must establish that a standard is reasonably necessary to the accomplishment of the work-related purpose. And C. The employer must establish that the standard is reasonably necessary to accomplish the legitimate work-related purpose. It ruled that the BFOQ at issue was necessary for flight safety. It ruled that the safety of passengers, said the court, goes to the core of the job, a cabin attendant. Being overweight impedes mobility. It accordingly attained the desired weight in spite of several opportunities given to him for the purpose. Subject to legal and contractual limitations, an employer may contract out the performance of some of his work. The management cannot be denied the faculty of promoting efficiency and attaining economy by study of what units are essential for its operations. It has the ultimate determination of whether services should be contracting out of services is an exercise of business judgment, a management prerogative. Manila Electric Company versus Quisumbing 326 Iskra 172. The subject of contracting out is discussed under the headings of payment of wages and unfair labor practice supra. The hiring, firing, promotion, and demotion of employees are traditionally identified as management prerogatives. However, they are not absolute prerogatives but subject to limitations provided by law, CBA or General Principle of Fairness and Justice. University of Santo Tomas versus NLRC 190 Iskra 758. The question as to who, when, where, and how these prerogative may be exercised are matters for the employer to determine, having in mind the said limitations. An employer's policy banning spouses from working in the same company must be cleared an invalid exercise of management prerogative absent an undisputed proof of business necessary behind such policy. Star Paper Corporation versus Symbol 487 Skra 228. It is the employer's prerogative to transfer an employee based on his assessment and perception of the employee's qualifications, aptitude, and competence. Gersha's Machine Shop and Auto Supply Incorporation versus NLRC 266 Iskra 97. And in order to ascertain where he can function with maximum benefit to the company. Blue Danny Corporation versus NLRC 314 Skra 401. An employee's rights to security of tenure does not give him where he will be most useful. Pantranco North Express Inc. versus NLRC 324 Iskra 140. The exercise of that prerogative cannot be seriously challenged except on the ground of Malafide Anderson Workers Union v. NLRC 291 Iskra 218. The transfer, however, must not be accompanied by a demotion in rank or diminution of salaries, benefits, and other privileges. Sidaya versus NLRC 176 Iskra 819. Otherwise, the action is not a mere transfer but a demotion, and demotion requires valid and legitimate grounds as well as observance of due process, Jarsha etc. supra. As to transfer with promotion, the rule is found in Dosh B versus NLRC 123 Iskra 296, discussed in connection with willful disobedience, infra. But the right to transfer employees cannot be used as a subterfuge by the employer to rid the establishment of an undesirable worker. For instance, frequent transfer of an employee to different posts for short duration of time are indirect ways of dismissing the employee. Philippine Independent Security Agency Corporation versus the Pitan 320 Iskra 124. The Supreme Court has also declared that it cannot sanction the practice of some companies which, shortly after a worker has become regular, transfer him to another entity whose owners are the same or identical in order to deprive him of the benefits and protections he is entitled to under the law. A from Security Services Incorporation versus NLRC 322 Iskra 283. Transfer amounts to constructive dismissal when it is unreasonable, inconvenient, or prejudicial to the employee, and it involves a demotion in rank or elimination of salaries, benefits, and other privileges OSS Security and Allied Services Incorporation versus NLRC 325 ISKRA 157. The relationship between labor and management, by its very nature, is characterized by reciprocal responsibilities. The employer's obligation to give his workers just compensation and treatment carries with it the corollary right to expect from the workers adequate work, diligence, and good conduct. Firestone Tire and Rubber Company versus Lariosa 178 ISKRA 187. This is the basis of the employer's right to discipline his employees. The prerogative to discipline employees and to impose penalties on erring once arises from the right of management to regulate all aspects of employment. Philippine Airlines Incorporation versus NLRC 227 ISKRA 226. That prerogative includes prescribing reasonable rules and regulation necessary for the conduct of the business, providing disciplinary rules to implement them, and taking steps to assure that the same will be followed. Soco versus Mercantile Corporation of Davao 145 ISKRA 586. If exercised in good faith for the advancement of the employer's interest and not for the purpose of defeating the rights of employees granted by law or contract, such prerogative will be upheld. Garcia versus Manila Times 224 ISKRA 399. So, ayun guys, dito nagtatapos ang ating discussion about the sa employers and his employees, yung mga rights nila. So, sana may natutunan kayo. Bye-bye!